Appeal in for the 5th District of the State of Florida is now in session. The Honorable Adrian G. Sow, Judge presiding. All persons have business before this court draw near. Give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Well, good morning to each and all of you. We are now in session for the 5th District Court of Appeal. As our esteemed marshal indicated, I am Adrian Sow, and I have the privilege of presiding this morning over the two oral arguments that are set for today. Let me first, if I may, introduce the two distinguished colleagues with whom I work. To my right is one of our more senior members of the court, Judge Rand Wallace. To my left is Judge Paige Kilbane, and it's a privilege to work with these two wonderful judges. If I can at this time, just ask everybody if you have a cell phone or other noise-making device, if you'd be kind enough to turn those off or place them in a silent mode so it doesn't disrupt the arguments this morning. Of course, we would be grateful for that. We have two cases set for oral argument. The first case is case 24-2975. It is D.L. versus Community-Based Care of Brevard, doing business as Brevard Family Partnership et al. We will, of course, reserve 20 minutes per side for oral argument. Appellant's counsel will have the opportunity to present a rebuttal. We typically reserve 5 minutes for that, but Mr. Gowdy, of course, if you prefer a different time, you can let us know how much time you wish to have for a rebuttal. With that understanding, Mr. Gowdy, as counsel for appellant, you are welcome to proceed, sir.
Good morning, may it please the court. Brian Gowdy of Creed & Gowdy on behalf of the appellant and plaintiff, DL. My client pled a negligence action against each of the three defendants. A negligence action, as we all know, has four elements: duty, breach, causation, and injury. Here, the fourth element, the injury, was a sexual battery inflicted on my client. Thus, this action fits comfortably within the text of the exception to the general statute of limitations as found in subsection 9 of section 9511 of the 2022 Florida statutes. As we say on page 18 of our brief, this provision can be broken into four parts. First, an action related to. Second, an act constituting a violation of section 794.011, which is a sexual battery. 3, a victim under the age of 18 at the time of the act. And finally, fourth, and the action must not be barred on or before July of 2010. My friends and I all agree that elements 2, 3, and 4 are satisfied.
You say barred, time barred. Time
right.
barred.
Time barred.
Yeah, sure.
I was trying to be brief to save
I
time. But yes, time barred. On element number 1, my friends and I agree that the interpretation of this phrase in the provision, an action related to a sexual battery, is a question that no Florida appellate court has addressed. And I hope that today my friends on the other side and I can give the court some guidance about how to write an opinion interpreting this language. I'd like to do that by rebutting the primary arguments in the three answer briefs. The first one is what I call the straw man argument that suggests that my client and I are advocating for a construction that will result in, quote, an unlimited number of causes to be brought at any time. You see other language in the LeBron briefs about wanting causes of action that are too tenuous or limitless, or words like this. They're littered throughout the answer brief, not the reply brief. And to support this argument, my friends on the other side tried out hypotheticals of very different facts than the ones pled in this case. Of course, this court must decide only this case, and I think the holding can be limited on the following principle. that in this case, the sexual battery is the predicate for the fourth element of the negligence cause of action. It will have to be proved at trial that a sexual battery occurred in this case and is the injury my client is seeking a claim for. If the sexual battery is the predicate of an element of a cause of action, at the very least, that action relates to a sexual battery. Indeed, I would suggest under that circumstance, the action is founded on a sexual battery, which is a more restrictive connecting term. But you don't have to get to that because the legislature here chose, as the Ham Court states, that the broader relate to. And in fact, I think the Florida Supreme Court's decision in Ham, which my friend in the Brevard brief cited, is the best illustration on how this court can rule on this case and leave for another day the hypotheticals that I'm happy to answer about.
Mr. Gowdy,
yes.
Question, and I mean, I'm going to kind of dumb it down here. Don't read anything into that other than from whom the question is coming.
Yes, sir.
That wording in the beginning of the statute, an action related to an act constituting a violation of, that seems like a lot of words to say in the event someone commits a violation of 794.011. Would you agree?
It's a lot of words. I don't follow the question.
Well, what would be the purpose behind, in your mind, an action related to an act constituting?
Well, I think it's defining a criminal offense.
Well, isn't that what 794.011 is?
Right. It's a sexual battery.
So, yeah, so I guess you answered my question. Isn't that a lot of words to get to the point? If someone commits a violation of 794.011, right?
Right.
It says the same thing, correct?
Right.
Okay.
Yeah, but I don't think there's any dispute here between the parties about that part of the statute, that we've alleged a violation of 794.011.
Well, but the wording "an action related to," that is central to
Yes.
this argument, correct?
Right. So it doesn't have to be. The legislature could have said that it was that an action based solely on a sexual battery. I like to use the term sexual battery just because it's easier than saying all those words, an act constituting a violation of 794.011. And so you understand, every time I say sexual battery, I mean to say all those words.
I think you answered my question.
Right, right. So, but the key language I think that the parties are disputing here is the first four words, an action related to. And what that related to means, it doesn't have to be that you're suing someone for a sexual battery. Related to means, I mean, it's almost, that's with respect to or connected to or concerns a sexual battery. As the Ham case explains, and it cites in turn Lamar from the U.S. Supreme Court, these words respecting, with respect to, relate to, concerning, about, if you go to dictionaries, you'll see they each kind of ping pong back and forth, and they all mean the same thing. And what you'll see in the case law is the courts say that those are broad terms, and a narrower term would be an action founded on a sexual battery. And then I think an even narrower term would be an action for a sexual battery. And so the legislature didn't say an action for a sexual battery. It didn't say an action founded on a sexual battery. It said an action related to a sexual battery. And we believe this case is an easy case.
Well, in taking your interpretation of that, that is a broader interpretation than some of the other language that you have used, correct?
That I have used?
No, well, that you just used in your
Yes.
in responding. And,
Yes.
And even this language is broader than the wording that I used, which was in the event someone commits a crime that would constitute a violation of 794.011.
Right.
That's a very specific, a much more precise
Yes.
and specific wording than what we have here in the statute, correct?
Yes, I
Okay.
agree.
My-
Yes.
Okay.
There would have been lots of ways for the legislature to narrow it to be either just solely an action for sexual battery, which means you could only, the statute of limitations is extended only for the actual perpetrator of the crime, or that it could have used other limiting language. Instead, the legislature chose to use what the courts have recognized as broad language related to. And I think my point in bringing up founded on was simply to say that if we had some of that more limited language, so I don't think, if it said in the event of a sexual battery, I'm not sure my negligence action would fall under that. But if the statute had said an action founded on a sexual battery, I think this action would qualify. Now, there's some others in the hypotheticals, which whenever we get to that I don't think would. And I think you're going to, the courts will have to look at each action individually. But here it's in the heartland. I mean, it's an element of the cause of action. It is the injury. And if we don't prove that injury at trial, I would concede that not only do we lose on the elements of the cause of action, but we would be out on the statute of limitations. They say, this will open the door if there's a physical injury. No, it won't. If we just show a physical injury and not a sexual battery, we're out. And if we just show a mental injury and no sexual battery, we're out. We've got to show a sexual battery at trial. And if we do, it's related to the action. It's part of the action. And what I wanted to point out in the Ham case, there the issue was whether...
I believe your position is related to, in this instance, doesn't mean the actual perpetrator of the crime.
Right.
Related to would be such as the appellee who was the spouse.
Right, all three of them.
Right. So it's a broader. Your reading and you're arguing the statute is broader. It applies to people that didn't necessarily specifically perpetrate the crime, but
Yes.
people who were overseers and or administratively over the situation, or in this case, the placement of the person in the home, correct?
Yeah, I agree with all that. The one thing I just want to say is it's not defined in terms of persons, it's defined in terms of the action. And Black's Law Dictionary tells us action is an exercise of a claim before a judge. It also tells us it's a lawsuit. It tells us it's a judicial proceeding. And so the question isn't whether a particular person can be a defendant. The question is whether the action relates to the sexual battery.
Okay, so you mentioned hypothetical. In what hypothetical, what fact is missing in this fact scenario
Right.
that would not encompass this situation as these appellees being related to this particular sexual battery?
What type of hypothetical?
What elements or what aspects of a hypothetical would absolve these particular appellees from any liability under this statute?
Yeah, so let me first say that I don't think you need to decide for all cases, but I will give you some hypotheticals that I think would be outside and some that would be borderline, and then I think ours is like in the heartland. So as far as would be outside, in one of the answer briefs, they bring up a fact pattern where a perpetrator commits a sexual battery on a minor in a hotel room. The perpetrator walks out of the hotel room, trips and falls, and sues the hotel for negligence, slip and fall action. In that action, that negligence action, none of the elements would involve the sexual battery. The hotel's breach of duty has nothing to do with the sexual battery. The duty has nothing to do with the sexual battery. Causation doesn't. The injury, none of those have to deal with sexual battery. And in fact, I would suggest that if someone were to actually bring that type of claim, they would probably get the sexual battery excluded under rules 90.401, 402, 403. So to me, that cause of action that's in the answer brief is clearly outside the statute. It's not even, the sexual battery is not even relevant at trial. much less related to the action. It's not part of the elements. So I think like a closer case that you don't need to decide today, but is in the answer brief, is they bring up the hypothetical about a sexual battery victim goes and sees a physician and then later alleges the physician commits malpractice in treating the sexual battery, okay? And this could, I think, come in a lot of different forms, not only in making a medical judgment mistake, a breach of the medical standard of care. You know, under Section 39.201, a physician has a duty to report a sexual battery committed on a child. So, you know, it could be there are lots of different fact patterns, but it could be the physician does negligent treatment of the sexual battery or fails to report to authorities. And all of those, I don't think the malpractice would meet the test I'm laying out here. Like, I don't think that the plaintiff would have to prove the sexual battery necessarily for any of the elements, because the injury would be what the physician inflicted after the sexual battery. But I think that case would be a really close call, because it'd be hard to say that if you sued, for example, the physician for a failure to report a sexual battery, that action didn't relate to a sexual battery. And if you were trying to say that, say, a mental health professional gave negligent care of the trauma from the sexual battery, that didn't relate to the sexual battery. So what I'm trying to tell you is that my test, it doesn't necessarily fit for every fact pattern, and I don't think you should feel compelled in your opinion to write for that. I think ours...
That'd be pretty hard to do, wouldn't it?
Be impossible. And as Justice Gorsuch just talked in some of his recent opinions, you know, the common law courts decide a case at a time, and that's how the law builds. And this case, I think, though, is like it's an easy one, honestly, because the injury is the sexual battery. It's a part of the element. And what my friends try to tell you in the briefs, you know, more or less, they have a couple different arguments. Like, for example, on page 14 of the Devereaux brief, it says that the appellant does not allege that Devereaux knew or should have known that Mr. Jones would sexually abuse the children in the care. First of all, that's factually false. Go to paragraph 23E of the complaint. It says BFP and or Devereaux knew or should have known that Bobby Jones molested other children in his home. But putting to the side the factual misstatement, I would submit it's wrong, because this is littered throughout the briefs. Their focus is on, hey, our breach of duty didn't involve us committing a sexual battery, or us aiding and abetting a sexual battery, or us conspiring on a sexual battery. And then they even make merits arguments, which they're going to get to do, which is we didn't know or shouldn't have known. Those are all to the merits of the negligence action, and those all go to the elements of duty, breach, and causation.
And Mr. Gowdy, just quickly, I know your time is expiring here.
Yes, actually, I'm already into it.
But for talking about the pleading, we're at a motion to dismiss stage on two of these and a motion for summary judgment. So, and we're looking at statute of limitations. Does that matter? I mean, if we're getting into merits arguments, those shouldn't be made at the stage we're at. Is that correct? Correct.
And a lot of the briefs is that. And I see I'm way into my rebuttal time, so I guess I should be quiet and sit down.
All right, sir. Thank you very much. Counsel for the appellees, and if you would let me know, do you intend to divide your time amongst the three of you? Is one lawyer going to address everything? Let us know how you wish to proceed in that regard.
We wish to proceed by all three of us coming up, and as you have questions that were specific to our clients, we'd address them and kind of answer the questions as we go.
All right, and that's fine. Is there going to be one counsel that addresses argument primarily except for a question that may or may not be asked, if there's a specific question to a specific party? Is there a lead lawyer handling the argument? That'll be you? All right, ma'am, you're welcome to proceed.
Mr. Gowdy's a lot taller than me. May it please the court, I'm Dorothy DiFiore. I represent Brevard. This is...
My name is Lauren Bobeck. May it please the court, I represent
Barbara Jones.
Good morning, may it please the court. My name is Michael Piccolo, and I represent the appellee, the Dever Foundation, Inc.
We do feel that we fall into a slightly different category with Devereaux and Brevard being more of the administrative component and Miss Jones being in the home. So we thought that you might have questions that were more specific to her versus us, but the two of us are essentially in the same position, we feel. We agree with Mr. Gowdy that this is a first impression for you and that you are faced with the task of determining just how important it is that everybody that's ever been in contact with a sexual battery of a foster child should be brought before the court at any point in time. And we're unfortunate that it's about sexual battery and about the horrible things that happen to children at the hands of people. But what the plaintiff is suggesting is that related to is almost unlimited. You heard that the doctor who fails to report that a sexual battery might in fact be involved. There's actually not a significant difference between that hypothetical and what we're talking about here, because the allegation against us is that we failed, at least as to us, that we failed to pick up some red flags years ago that would have told us that Bobby Jones was going to have a sexual battery going on, and that's why we negligently licensed the home and placed DL there. And then there's we failed to ensure that the home was safe, which is essentially saying we failed to take action after we learned, because we knew or should have known as of June when it was first reported. And that's essentially the same thing as the physician who doesn't report the sexual battery. And so now you're beginning to drag in physicians, you're beginning to drag in all the people that ever have in touch with this child based on the fact that the injury is the sexual battery. The very important point that he made is that he believes that it's focused on the act and not the actor. And I think that in fact it turns it around, because the cause of action is against the actor. They expanded the liability for the actors who perpetrate these horrible acts against children. They did not say anyone related to that in all time. They use this phrase related, right? And we talk at length in our briefs about the interpretation of related to. There's the fourth district.
The related to aspect of this case involves these two appellees, Devereaux and Brevard, allowing the placement to take place and the monitoring of the placement, correct?
So I don't know that the monitoring of the placement is very well pled, but I think it might be inferred from some of the statements. If you look at the complaint in the paragraph 23 that he describes things that we knew or should have known, there is a discussion about the fact that Bobby Jones molested other children in the home. Now, again, remember the argument is we negligently placed her there, right? So that would have been a decision that was made before these allegations were raised in June of 2014. I am not talking about proof, I'm talking about allegations. So in the first paragraph of 23, we talk about numerous prior reports, criminal history, all these things that happened long before June of 2014. The only thing that seems to come after June of 2014 is the allegations of ongoing sexual acts, and the foster parents were aware Bobby Jones had molested other children. Again, there is no allegation that information was ever known to Devereaux or Brevard prior to the June 2014 discussion about sexual abuse. The sexual abuse, though, in June of 2014 was not Bobby Jones' sexual abuse. June of 2014, it was about child on child. It was actually about a DL doing something inappropriate. And that's what's in the complaint. I'm not looking at the facts. I'm not trying to get into the merits of this. I'm asking you to look at what they've pled. And what they've said is that in June of 2014, it was discovered that DL was doing something sexually inappropriate and that there was other child on child. Again, not anything to do with Bobby Jones until it came out later. So what we knew or should have known in 2014 is actually not really the basis for negligent licensing. If you look at the allegation against Brevard, and it's identical against Devereaux, in count 1, after going through what all of our duties are, they say BFP, that's us, negligently licensed Bobby Jones and Barbara and allowed DL to be placed. all of which occurred before June of 2014. So this is all about what we should have known before, and yet he has got no allegation that we knew or should have known about it before June of 2014. Now, if there is an inference to be drawn that after June of 2014 and before November of 2014, when DL was removed from the home, and it was that short, the allegation of child on child arose in June, she was removed, the home was closed by November, and that's what's in the complaint. There's additional information, but we're not going to get into that. And then it was a year later that there was discussion of Bobby Jones' sexual battery on her. And it is Bobby Jones' sexual battery that is the basis of this. He made that very clear. It's the sexual battery of Bobby Jones. It's why he's suing Miss Jones, right? So the allegations don't show that we knew or should have known at the time of the placement, or even up until June of 2014, that there was any sexual misconduct of any kind that would have said this relates to a sexual battery. It's only after June of 2014, through the limited window of November 2014, that there may have been some failure to monitor.
Are we into the merits at this point?
No,
I
I'm
know
not.
I know you mentioned earlier about we're just asking you to look at the allegations, the complaint, et cetera.
That's what's in the complaint. So that's all. I don't know. I came into this case after the fact as the appellate attorney. I don't know what the actual facts are. I have that actually very easy. I can only go with what's in this complaint.
It seems to me the entirety of the case determines how the court is determined by how the court interprets related to.
It does. It absolutely
That seems to me
does.
to be, it's not a timeline of events, it's not what is in fact or what is alleged or in fact to be known or should have known. It is how do we interpret the phrase related to. You agree that's this
do
case?
agree. I absolutely do agree.
There's no dispute that the allegations are sufficient to allege violation of 794.11. You agree with that? That's
By
not
Mr.
disputed.
Jones, correct.
Okay. So what I'm trying to wrap my arms around just a little bit, and I would welcome your response or anyone's response to Mr. Gowdy's argument of hypotheticals. It's always an interesting dynamic. Sometimes arguments can devolve to hypotheticals as to, well, this hypothetical situation would interact with this case in this particular way. It's difficult for courts to write a case, write an opinion anticipating every hypothetical. So
Agreed.
should we cast our gaze only upon the facts presented here and not be overly concerned with hypotheticals? How would you respond to his argument?
Well, actually, we think that this court can give guidance to the trial courts in Florida that are going to be addressing the foster care system in regard to sexual battery. Hopefully it won't be often, but we know it happens. And we believe that much like the tests we put out for the substantial relationship tests in a choice of law or the forum nonconvenience test, that we look for a direct and specific connection. When you look at the interpretation of related to that's come through, even in the Ham case, the court said, although the account stated claims could not fairly be said to be based on, under, or pursuant, there is nonetheless a clear and direct relationship between the credit contracts and the account stated. A clear and direct relationship. I think that is a standard that you could apply in every context. Does it require a case-by-case analysis? Yes, but the standard is still the same. The substantial relationship test for choice of law has the 4 criteria, and then you look at the facts of your case to see if it's there.
Do the facts as alleged in this case satisfy that test?
I do not believe they do. Because what they're saying is that any act whatsoever occurring prior to this sexual battery makes you related to. When you look at the statute and the evil it was designed to cure, I think we can all agree that related to is not necessarily the clearest language, and perhaps we can go outside of just 2 words, that we can look at what was it intended. We all know this came out of the church abuse scandal. And who did they want to get? They wanted to get the church, the Boy Scouts, whoever was actually complicit in enabling this abuse to continue. They went for vicarious liability. I wrote down some things that I thought you could look at in terms of maybe deciding if it was a direct. Is there vicarious liability on the part of the person you're suing for the direct action? That was the archdiocese. They employed the priests, they kept the priests in the school, they hired them, they trained them, they moved them around. Direct employer respondeat superior. absolutely spot on. Those people should be responsible for the acts of their agents and their employees. So we look at something along those lines, like a direct respondeat superior or vicarious liability.
But counsel, why would we rewrite the statute? Whether that was the legislative intent or not, it doesn't say substantial relationship. That's a defined term in the case law. I understand that. But relate to or related to is a much broader term, and that's what the statute uses. So how would we superimpose that, a substantial relationship test or any of these other tests that you're asking us to sort of grift on to the statute? Why would we do that? How do we have the ability to do that from our seats?
We're actually not asking you to graft anything into the CERM. We're asking you to provide guidance as to what related to means.
But why would it mean something different than what it says?
Because the broadness of that term makes it untenable. It makes it so broad that you've eliminated the purpose of statutes of limitation. You've opened up liability to the entire world, essentially. So if you look at the discussion of related to at the United States Supreme Court, at the 4th District Court of Appeal, at the 11th Circuit Court of Appeals, they all agree that the courts need to say related to is not the unlimited connection that could exist. They talk about how you basically eliminate the purpose of using that. It's supposed to be a somewhat of a term of limitation, and yet if you broadly construe it, then it doesn't even accomplish that at all. So the courts have specifically said that when looking at this specific term related to, there needs to be some sort of guidance as to how far does that go.
Well,
and that's all we're asking for.
Well, would not the guidance come from a fair reading of the language chosen deliberately by the legislature?
Well, we are all struggling today to find the guidance as to what related to means. So that's what the problem is. They use this term related to, for which there is very little jurisprudence, and they are expanding the liability potential far beyond what the situation out of which this change in the law arose, and now they've left us with this very broad, vague, ambiguous term related to.
So if you were in the legislature, since certainly hypotheticals have been presented, if you wanted to write the broadest statute possible, would you choose language different from what we have in front of us?
Well,
Can you think of anything more broad than related to?
I do believe that you can expand it with more connections. For example, I work with insurance companies, and when they want to exclude an assault and battery, they've made it arising out of, related to, connected with, and they go on, and they make it very clear that anything that mentions the word assault basically will not be covered. So there are ways to do that. Arising out of is also incredibly broad, and the courts have addressed that as well. So, but even arising out of requires a nexus.
Is it more broad than related to?
I'd have to look. I mean,
it's-
because there's not much case law on related to. There's a lot of case law on arising out of, which makes it very, very broad. And so related to is not that much different from arising out of, I think, so.
Okay.
So you think your reading of the statute related to and this and these facts applied to this law would limit it to only the perpetrator of the crime?
No, I do not. I believe it could relate to anyone who was responsible for him. Now, Ms. Jones does not think she was responsible, and she does not believe that there's an allegation of that, but we are not responsible. The fact the legislature has very specifically said that the lead agency is not responsible for any negligence on the part of their subcontractors. They've taken a great deal of trouble to make sure that in the foster care system, each party is only responsible for their own acts. All right? So we are not in a position to be vicariously responsible for the foster parent. We are only responsible for our acts, which is why they start alleging about our acts, which occurred well before this. And the accusation is that negligent credentialing back in 2006 should relate to an act of sexual battery in 2014. And I think that's where we lose the connection. As I said in my brief, it's about how many degrees of separation from the battery do we get. Every other case in which there's been this sexual battery situation, the claims have been directly against an employer. I don't think that's the only thing. So, for example, there are also, when there's an ability to control the actor, like the churches and the Boy Scouts, to some extent they had control even if they weren't vicariously liable for them. And I do think, obviously, if we had the ability to control Mr. Jones in the sense of we were his employer, we were directing the contract, et cetera, the only thing we had the ability to control was the licensing, right? And the information, according to the allegations of the complaint, was not there on our negligent licensing. And our negligent licensing is not negligent because of the sexual battery. Our negligence was allegedly because of something else. So we've been brought into this lawsuit because we failed to pick up on some things that might have made them not an ideal situation. But now we're going to be sucked in forever because, unbeknownst to us, somebody committed a sexual battery at the house. And it's just, that's where I think you get too far apart. Is it the teacher and the school board? Maybe. Is it the priest and the school and the archdiocese? Yes, that's who I think is involved here. Related to the actor, right? We're relating to the actor. The act of sexual battery has occurred. Who committed it? That's what the idea is, right? Who committed the battery, and then who relates to that person and how. And we actually didn't license Bobby Jones, by the way. We only licensed Barbara Jones. So he was in the home. And I don't think that's relevant, but it was alleged that we licensed him. So we think that if this court can set out some parameters of how far and tenuous can it be, because the courts have done that consistently with this phrase related to. The only case in Florida is the Ham case, which talks about a direct and substantial, clear and direct relationship between the cause of action and the actions of the party that you're after. To simply say anytime there's a sexual battery, anyone who's ever come in contact with this, who is connected in some tenuous way, should be sucked into the litigation forever and ever, is I think, an unreasonable interpretation of a statute that's not exactly clear and unambiguous. And when you have a clear and unambiguous statute, then you don't go outside, right? When you have some ambiguity, you can go outside the plain language and look at how do we guide the courts in interpreting that. I would like to give 3 minutes.
Your argument is related to is ambiguous.
I do think it is. And I do think that it's so broad that it requires assistance in discussing what it means. And then you look at the purpose of this statute. I would like to give my co-counsel an opportunity to discuss their perspectives on this. I don't want to hog the entire stage. And I don't know if you have questions for either of them from a perspective.
I do think that Ms. Jones' position deserves at least a moment in time, because obviously she has a different position than the actors who licensed and who supervise the licensing agency. But I still think that what the appellant is trying to do here is, as long as there is a sexual battery, everything that harkens back to that. So Ms. Jones is here because of her proximity. And I think the ambiguity of the statute is that it could be related to the action or related to the actor. And so either way, we're capturing these very broad actors. And what that does is it creates a policy atmosphere where for forever, Ms. Jones can be held liable for something that she had no control over, her husband. Whether we have control over our husbands or not is maybe an argument for another time, but that connection is tenuous. That connection is not as direct as if, like in the Catholic Church's scenario, if there was another priest who concealed, right? Then you don't have an employer-employee relationship. We don't have any employer-employee relationships in this case. But if they are participating or connected in a direct way, if there are facts that connect.
Is there a closer relationship than a spouse?
I mean, maybe a sibling or a child, but I think for these purposes, the connection has to be also to the action, to the sexual battery. And I think that goes into what is alleged in the complaint.
Sure, but if your argument is employer-employee type relationship and what information known to the employer related to conduct of an employee, how would that not with equal or more force apply to, as alleged, a wife who knew or should have known of a husband's actions or tendencies, etc. I don't understand that distinction at all.
I think that the problem is they have not, in the complaint, alleged sufficient connection to that. I think there are facts maybe that could present that scenario. But
So if sufficient facts are alleged in a complaint as it pertains to one spouse's knowledge in a given case, then that may sufficiently be related to for purposes of the statute. Is that what you're saying?
I'm saying that I could see a scenario where a spouse could be held liable for the acts of their husband.
So then your argument is more one of, is a factual-based argument, not a language-based argument.
Well, I think they're one and the same, Your Honor. I think you can't be related to without some facts that relate to the action, right? Otherwise, then it's just the sexual battery that relates everything. So as long as we have a sexual battery, everything, regardless of the facts, are related to the sexual battery. I feel like you have to have the confluence of both of those things. Otherwise, we're bringing in everybody, like the plaintiff's saying we're not. But I think their definition is almost like an ends to a means. Like, if you have the injury and the injury is sexual battery, then we've got a great long tail. And
Okay.
now it's forever.
All right, so let me do this. Marshall, if you would, we'll grant 2 minutes and a total of 2 minutes additional time for each side. It would be cumulatively for the appellees and then 2 minutes for Mr. Gowdy, so that you all can conclude your argument.
And I think I'm going to pass to Mr. Piccolo since I've spoken enough.
And as my co-counsel set out originally, the position between Devereux and community-based care are very similar factually. One other thing I would bring up with respect to the statute itself, I not only think it's ambiguous, I think it's vague. I think we're trying to draw lines here in terms of where is a line for related to needs to be. Focus on knowledge, focus on action, as Judge Wallace brought up. It's an action related to an act constituting a violation. And that, related to is the crux of the argument, but I think constituting a violation of the act is also very important here as well. So I would just conclude with that.
And finally, I think that it's very significant that when you asked Mr. Gowdy for what case wouldn't fit, he could only come up with one hypothetical that was in our briefs, the trip and fall. He didn't really give you any other examples when it would not be related to a sexual battery, and I think that's exactly the problem here.
And we'd ask you to affirm.
Thank you all very much. Mr. Gowdy, with the additional time granted by the court, you have 5 minutes, 35 seconds.
Thank you, Your Honor. I could give you, if you gave me 20 minutes, I would give you a long list of hypotheticals. I'll just give you one more. Suppose that there's a non-payment under the contract between Brevard and Devereux, there's a non-payment and somehow Devereux didn't get their money. I don't think this statute of limitations extender would allow Devereux to have more time to sue Brevard for that, just because there was a sexual battery involved in the placement. So, and I could just start listing off hypotheticals, but we don't have time for that. And I think you're right. We need to decide this case. And what I did hear opposing counsel say at some point, well, first of all, I said we're all struggling. I'm not struggling. This is an easy case. It's in the heartland. I gave you a harder case, the doctor one. I didn't ask you to decide it. I just wanted to point out there'll be harder cases later. But the breach of contract I just mentioned is easy. The trip and fall is easy. This case is easy on the other side of the line. I also heard counsel at one point say the basis, maybe I misheard her, said the basis of the claim is a sexual battery. That ought to be the end of it. All these other arguments you heard, you would hear those exact same arguments if my client filed within 4 years of the sexual battery, which is the normal statute of limitations. Every single argument is about whether or not they knew or should have known. Those are the arguments you have under the common law of negligence. They're arguing about proximate cause. That's a negligence. We're just here. They're acting like, oh, we're going to get sucked in. Well, if my client had filed this action within 4 years, we would be litigating all these issues they're talking to you about. My friend mentioned the statute in Chapter 409.993. We're going to litigate about that later. They're going to claim, oh, we're not responsible. That's not before the court today. You just have to interpret 4 words. An action relating to. They've conceded there was a sexual battery. And then I heard my friend say, well, you asked a great question. How could you make it any broader? And my friend said, well, insurance companies use words like related to, arising, and she ran off a whole list. Please go read the dictionaries. Those words she all mentioned are in the dictionary definition. Please go read the Lamar case that's discussed in the Florida Supreme Court's Ham case. Lamar is a bankruptcy case. They talk about how these words all mean the same thing. She just told you that the legislature doesn't have to be like an insurance company and give an infinite list of synonyms. It doesn't have to give the whole list in the dictionary. But related to is synonymous with respect to, respecting, and these are the broadest terms possible. As far as Judge Kilbane, you're absolutely right. Judge Soud, and I think all 3 of you understand this. We look at the text to discern the meaning of the law. One date I'd like everyone to etch in their memory is August 25th, 2022. That's when the Florida Supreme Court decided Connage. And in Connage, the Florida Supreme Court made it very clear that we were receding from 30 to 40 years of precedent under Holly v. Auld. If you go back and you look through all their cases where they're citing, hey, we get to look at the ambiguity and then we get to look at the legislative history and we get to look at all this extraneous stuff, that's all flowing from Holly v. Auld. August 25th, 2022.
Intent's no longer the poll star.
I'm sorry?
Intent is no longer the poll star.
Exactly. And that's what all the cases in their brief are from. They're before August 25th, 2022. And Connage was a landmark case in the textualist here, and I still see even courts sometime citing cases from the Holly v. Auld line of cases. This court in Taylor and TG v. United has rejected the legislative history. I won't go through that. I do want to go through the Ham case because I actually think it's great for us. So there, the issue was whether an account-stated cause of action was, quote, with respect to the contract. That was the statutory language. With respect to, as I said, is synonymous to related to. And, it was 6-1 decision, but the court reasoned an essential element of an account-stated cause of action is proof of the existence of a business relationship between the parties. And then the court said, the business relationship here was predicated on the credit card contracts. That's page 49 of the reporter. I'm sorry, 949 of the reporter. And we have this, and so the court then came to the conclusion, even though the cause of action was not for a breach of contract, it was for account stated, they said that it was with respect to the contract. And we have the same thing here. An essential element of a negligence cause of action is proof of injury. And the injury here is predicated on the sexual battery. They even said it. Game over. Thank you.
Yes, sir. Thank you both. Thank you all very much for well-presented, well-prepared arguments.